stop what you are doing. If you have a pending immigration application, a green card, an adjustment of status, a petition waiting at USCIS, what I'm about to share with you in the next few minutes could directly affect what happens to your case. As of March 30th, 2026, USCIS issued a formal update that has major implications for family-based petitioners, adjustment of status applicants, and thousands of people who have been waiting, some for months, without any movement on their cases. There is genuinely good news buried inside this update, but it comes with important conditions, and if you don't understand those conditions, you could misread your situation entirely. So stay with me through this entire video, because the details matter. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't speculate. I don't sensationalize. I go directly to the official source, USCIS, the Department of Homeland Security, the State Department, and I translate what those documents actually mean for real people in real situations. Before I go any further, I need to be transparent with you. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. Every situation is different, and nothing I say here constitutes legal advice. What I can give you is a clear, grounded breakdown of what just happened and what it means for you. So let's get into it. On March 30th, 2026, USCIS published a significant formal update on what they are calling their strengthened screening and vetting measures. This wasn't a routine announcement. This was a comprehensive, detailed statement that laid out, for the first time publicly, exactly which application categories have been on hold, why they were placed on hold, and critically, which holds are now being lifted. That last part is where the good news lives. Let me walk you through this step by step. This entire situation stems from 3 presidential actions that have been reshaping USCIS operations over the past several months. First, Executive Order 14161 directed all federal agencies to vet and screen foreign nationals to the maximum degree possible, with particular focus on regions identified as having national security risks. Then came Presidential Proclamation PM-949, which restricted entry from countries that USCIS determined lacked adequate screening and vetting infrastructure. And then Presidential Proclamation PM-998 expanded that list even further, bringing the total to 39 countries affected by entry restrictions of varying degrees. These proclamations triggered an internal USCIS review of essentially their entire pending workload, and when USCIS completed that review, they issued 3 policy memoranda, PM-602-0192, PM-602-0193, and PM-602-0194, that placed holds on specific categories of applications. Now, those memoranda have been in effect for some time. What changed on March 30th is that USCIS told us publicly, officially, and in writing which of those holds are being lifted, and that is the development we need to talk about. But here's where this becomes critical. When I say good news, I want to be specific, because this update is not good news for everyone equally. The categories where USCIS has confirmed holds are being lifted include the following: asylum applications from nationals of countries not on the high-risk designated list. Those holds are being lifted, and processing should resume. Certain petitions filed by U.S. citizens are being released from hold status. Intercountry adoption forms are being cleared. Certain rescheduled oath ceremonies for naturalization are moving forward. Cases that require a statutory or regulatory decision issuance have been cleared. Refugee registrations specifically for South African citizens and nationals have been released. Certain special immigrant visa petitions, those are SIVs, have been cleared, and certain employment authorization documents, known as EADs, are being processed again. That list is meaningful. For the family-based petitioners in this audience, the key item is this: certain petitions filed by U.S. citizens are now being released from hold. That includes I-130 petitions, the petition for alien relatives, which is the foundation of virtually every family-based immigration case. If you're a U.S. citizen who filed an I-130 for a spouse, a child, or a parent, and your case has been sitting without movement, this update signals that USCIS is actively working to release those holds. Not all at once, not overnight, but the mechanism is in motion. Now, I want to make sure you understand the other side of this, because this is what many green card applicants are misunderstanding. The good news applies primarily to applicants who are not nationals of the 39 countries listed under Presidential Proclamations PM-949 and PM-998. If you or your beneficiary are from one of those countries, holds may still be in place on your application. The full list includes countries under full entry bans: Afghanistan, Burma, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burkina Faso, Laos, Mali, Niger, Sierra Leone, South Sudan, Syria, and Palestinian Authority travel document holders. There are also countries under partial entry bans covering immigrant visas and certain non-immigrant categories, including Cuba, Venezuela, Nigeria, Senegal, Angola, and others. If you are a national of one of these 39 countries, the situation is more complex, and you absolutely need to consult an immigration attorney to understand exactly where your case stands. There's one detail most people are missing about this update, and it's important. USCIS was very deliberate in the language they used. They said, and I'm summarizing here based on the official document, that the review process for lifting holds requires multi-office review for each individual or group case. This is not a blanket release. USCIS is going through categories and subcategories and evaluating cases one by one or in groups. That means the processing resumption is real, but it is gradual. You may not see immediate movement on your case even if your category has been cleared. This is a process, not an overnight switch. Manage your expectations accordingly and keep monitoring your case status through the official USCIS case status tool at uscis.gov. Let me give you a real-world scenario so this all makes sense on a human level. Imagine a U.S. citizen. Let's call her Maria. Maria is a naturalized citizen originally from Colombia. She filed an I-130 for her husband, who is currently abroad waiting for the process to move forward. They have 2 children together. The petition has been pending for months with no updates, no interview scheduled, nothing. Maria didn't understand why. She kept checking the USCIS website, nothing. What she didn't know, and what the March 30th update finally clarifies, is that her case may have been caught in a broader hold placed as part of the enhanced vetting review, even though Colombia is not on the 39 designated countries list. Under this new update, USCIS has confirmed that certain petitions filed by U.S. citizens are being released from those holds. So for Maria, this is genuinely encouraging news. It doesn't guarantee a timeline. It doesn't guarantee an interview date tomorrow. But it means that the bureaucratic wall that was blocking her case is beginning to come down, and knowing that, understanding why the delay happened and what is changing, gives her and her attorney the information they need to follow up appropriately. This could affect you even if you're not in the specific visa category I just described, so let me give you a concrete action plan for what to do right now. Step 1. Identify exactly where your case stands. Go to uscis.gov and use the Case Status online tool. Enter your receipt number. Note the last update date and the status language. Screenshot it. This is your baseline. Step 2. Determine whether your nationality or your beneficiary's nationality is on the list of 39 designated countries. This matters enormously for understanding what kind of hold, if any, may have affected your application. Step 3. If you have an attorney, contact them this week, not this month, this week, and ask them to review your case in light of the March 30th USCIS update. If you don't have an attorney, this is an important moment to consider consulting one. Step 4. Review your social media presence. This may sound unrelated, but USCIS has explicitly stated they are now conducting social media and financial vetting as part of enhanced screening. Make sure your online presence is consistent with the information in your immigration applications. Any inconsistency can create a complication. Step 5. Plan for delays in employment authorization document renewals. USCIS has also shortened the validity periods for certain EADs to allow for more frequent security checks. File your EAD renewal as early as you are eligible. Do not wait until the last moment, because gaps in work authorization can have serious employment and immigration consequences. Now let me put this in the broader policy context, because the March 30th update is not the final chapter of this story. It is a chapter in a longer process. USCIS has confirmed that additional changes are still in development. They are building what they describe as a layered vetting plan, a multi-layer framework that will incorporate both classified and unclassified information, expanded criminal history checks, enhanced identity verification, and ad hoc security checks on a case-by-case basis. They are also developing specific adjudicator guidance, meaning instructions for the officers who actually decide your case, aligned to country-specific risk factors identified for each of the 39 designated nations. What that means practically is this. The enhanced vetting environment is not temporary. It is being institutionalized. New procedures are being drafted. The State Department is involved. The Department of Homeland Security is involved. This is a structural shift in how immigration applications are processed, not a short-term policy experiment. The Visa Bulletin for March 2026, independently, showed active management of visa numbers, with the Department of State advancing filing dates across family-sponsored and employment-based categories to build a reserve of applicants for the remainder of fiscal year 2026. USCIS confirmed they are honoring the dates for filing chart for March, which means eligible applicants in many categories can file their adjustment of status application before their priority date is current for final action. That is a separate piece of good news that gives applicants more time to get their paperwork in order. However, this protection may not be permanent. The advancement of filing dates is a tool the government uses strategically. Former visa office officials have noted that the March bulletin reflects positioning for the remainder of fiscal year 2026, and retrogression later in the fiscal year remains a real possibility. If you are in a position to file your I-485 right now under the dates for filing chart, talk to your attorney about whether it makes sense to do so. Waiting could mean losing that window. I want to close this section by bringing it back to what really matters. Immigration is not an abstract policy discussion. It is the story of real families. It is the story of a mother who filed a petition for her adult daughter and has been waiting 2 years. It is the story of a man who has worked legally in this country for 8 years and is now watching his EAD validity period shrink. It is the story of a couple separated by borders, trying to understand why their case has not moved and whether it ever will. These delays affect family unity. They affect employment stability. They affect financial security. They affect long-term residency plans, naturalization timelines, and ultimately, the entire trajectory of someone's life in this country. That is the weight of what we are talking about when we analyze immigration policy. It is never just paperwork. It is people's futures. And that is exactly why it matters that you stay informed, with accurate, fact-based information, not rumors, not speculation, not fear. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Now I want to hear from you. Drop your visa category in the comments below, whether you're F2A, F1, employment-based, pending asylum, adjustment of status, whatever your situation is, put it in the comments. You are not alone in this process, and this community can be a powerful source of support and information when you're navigating something this complex. If you found this video helpful, please share it with someone who is waiting on an immigration case right now. They may not even know this update happened, and hit that like button. It tells YouTube to show this video to more people who need this information. I'll see you in the next update.